Answered and hear the latest breakthrough information for you and your family. Our product line, Quantum Nutrition Labs, delivers what others only promise, nutrition that really works.
KCAA, where every day is a great day.
Thank you for tuning in for this edition of Justice Watch with Attorney Zulu Ali. I'm Attorney Zulu Ali with the Justice Watch crew with Rosa Nunez, Michael Bilal Clark, and Dr. Akil Bashir. This week, like we do every Sunday, we will discuss important and critical legal issues affecting our communities. Our guest today is Attorney Christopher Hernandez. Thank you for joining us today, Chris. Chris Hernandez holds a Bachelor of Arts degree in Political Science from the University of California at Irvine. He has a Master's in Political Science from Cal State Fullerton, and he has a Juris Doctorate from California Western School of Law. Currently, he is a trial attorney and criminal defense attorney here in Southern California, handling a wide variety of cases, including both civil and criminal issues. So today we're going to be discussing judicial misconduct. And I guess to start, we'll first begin by talking a little bit about who are judges. And basically, we'll be discussing both the issues of state and federal judges. And just so that people will understand kind of how the judicial system works, we have at the federal level and at the state level, we have trial court judges. Then we have the Court of Appeal judges, and then we have Supreme Court judges, and that's both at both the state and the federal level. Now, of course, at the federal level, judges are basically nominated by the president and confirmed by Congress. And at the state level, basically, it depends on how the vacancy actually occurs. For example, if a judge retires like in the middle of his term, then basically what is the governor appoints someone to fill that seat until the next election, and then if a judge actually retires, not at the middle of the session, but if there's an open seat, then actually there's actually what they call a nonpartisan election. And just so that we're clear, federal judges are appointed for life, and state judges are actually appointed for a period of, for the trial courts are 6 years at the Superior Court level, and at the Court of Appeals they're actually 12 years. And so basically the role of a judge are pretty much like a referee, what I always call, like, basically unlike the prosecutor or a police officer, the judge is supposed to take the role of someone who basically is somewhat like a referee. And that's kind of their function. And I know that it's something that's not often spoken about, Chris, but I do know that being involved in trial cases, I think that it's one of those like kind of unspoken things that you very seldom hear of. I mean, we hear about the police, we hear about sometimes the prosecutor, but we don't very often hear about judges. So when it comes to judicial misconduct, at least in your experience, how would you define judicial misconduct?
Well, judicial misconduct is a serious deviation from the accepted practice of a judge in the judicial arena. And that's just the cut and dry, definition of judicial misconduct. Now, there's several different types of judicial misconduct. There's discourtesy and there's number 2, I have a list of bias and prejudice. 3, partiality and prejudicing. 4, coercing waiver of a right. 5, coercing settlements. 6, impairing examination of a witness. And 7, receiving evidence out of court. And 8, ex parte communications. 9, coercing and improperly communicating with the jury. So those are the different types of actual judicial misconduct that have been before the court and have been challenged by litigants or by attorneys in regards to judicial misconduct.
Yeah. Now, I know as far as judges, I think that kind of the being in the arena, and kind of what I see with regards to judges is kind of like the judge is somewhat of the gatekeeper. And I think that most people, when they imagine their day in court, then they imagine that if I have a grievance against an individual, or if someone actually has a grievance against me, whether it's a criminal or a civil case, that basically I'm going to go into court, the courtroom doors are open, and I'm going to be able to go in and adjudicate my case. But I think that what people truly don't understand, and what I see is kind of the issues, are that a judge, before you even get to trial, of course, you have all these pretrial motions. And basically, for example, you have summary judgment motions, you have demurrage, you have all these procedural things that come into play, and oftentimes prevents an individual from having his case actually adjudicated just simply by a judge kicking the case out because of some sort of procedural issue. So how do you believe, or at least in your experience, do you believe that judges' biases sometimes play an extremely important part in preventing individuals from having their days in court?
Well, I can give you a personal example of some judicial misconduct that I actually witnessed myself, and I'm not going to name drop or anything in regards to the judge or actually even the county of where it occurred. But I seen a defense attorney. I came in as co-counsel on this case, and the reason why I was brought in as co-counsel was because the attorney that was doing the case at the time, he needed some assistance, some oral assistance. So I came in to fight with opposing counsel. So when I came in, I was kind of, I took a little backseat to kind of find out what was going on. I was there maybe 10 minutes, and this attorney put his finger in my co-counsel's face, told him to shut his mouth, shut up, and the judge just allowed it. And he continued to do that throughout the trial. Multiple times, told him to shut up, shut your mouth, and all he was doing was doing an objection that was permitted by law.
Right.
And the judge allowed that. The judge allowed him to ridicule my co-counsel. At one time, right before recess, co-counsel had said something that may or may not have been, proper. And this opposing counsel basically had said, started to laugh at him. And it wasn't just a regular laugh, like it was, ha, 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 ha. You're incompetent. You're incompetent. And he just continued to do that for about 10 minutes, and the judge didn't do anything.
Right.
And at the end of the trial, there was a witness that was up there. And this attorney, his last questions were, how does it feel to raise a monster? And the judge told him, that's enough. And he said, well, I just want to know. He said, you raise somebody that beats women, like how does it feel to raise a monster? And he said it again. Judge didn't do anything again. And third time, he says, okay, no more questions. Oh, you were beat you were beat by your husband, and that's why you raised a monster. And again, the judge didn't do anything. And as I was watching this, I really didn't know what to do. I was kind of taking a back seat. He had the microphone, my co-counsel, and it was just a situation where not only was opposing counsel acting in a way unbecoming of an attorney, but the judge was also following suit. For whatever reason, I heard some conversation about going to a golf country club or something during the weekend, and so there was some bias in there, in my opinion, and that was a clear example of judicial misconduct.
Right. Yeah, I mean, I think that, and I think that people are kind of surprised. And generally, what happens, something that I experience a lot, is that individuals who have those experiences, especially negative experiences with the courtroom, oftentimes it ends up being a negative experience somehow related to the judge that's somewhat unexpected, because they don't expect judges obviously to be biased. And as a, you know, as a referee of the judicial system, or as the courtroom, then I don't believe that people understand how important it is, or how much it's an issue of the fact that you don't have a judge that's basically fair and impartial. You know, I think that basically the way that the judicial system works, and I think that's one of the things that the typical layman is not privy to, is that basically the judge, in most cases, unless you're in a jury trial, is somewhat the trier of what they call fact and a trier of law. He makes the determinations of what law applies and what facts apply, or the fact finder, whether what's true and what's not true. And, you know, one of the things that I find with the judicial system, and one of the reasons why, you know, everyone's looking for a way for the laws to change. Whenever we change laws, that's always an issue, is changing the law. And the way that you change the law is basically the lawmaker makes the law. And then when we're talking about our legislatures, they introduce legislation, they make the law. Once the law is actually made, then basically the administrator of how that law is implemented really is the judiciary. And oftentimes when cases are made, for example, we've heard of cases like Brown v. Board of Education. We've heard of many different cases that by name. And those cases actually are what they call, you know, case law. In other words, they set precedents in the way that we do things. And judges, especially appellate court judges, are responsible for that. But what has happened, I believe, in recent times is that, and one of the reasons why I feel like in our profession, we're not those of us who are really interested in changing the law and making things better and challenging the law, are kind of prevented from doing so, because unlike in earlier years where you had Brown v. Board of Education and you had someone like Thurgood Marshall who was able to go into the court system and make those changes, we don't have mavericks like that anymore. And the reason we don't have mavericks like that anymore is because we are very limited, and oftentimes attorneys are crucified for challenging laws, you know. And for me, I think that that's so unfair, because, you know, someone like myself, who I consider myself a throwback type of attorney, you know, I'm influenced by people like Avon Williams and Thurgood Marshall and Charles Hamilton Houston and the greats, you know, who basically went in and challenged the law. Nowadays, if you do that, I mean, you're putting your career on the line.
That's correct.
Yeah.
And I mean, even me coming on the show to talk about this issue, I mean, I had to think twice about it, because I'm talking about judges here. But, you know, I thought about it, and my desire is one day that I will be a judge.
Yeah.
And I said, well, if I'm going to be a judge, I might as well put myself out there right now and, you know, talk about what's right and what's wrong, you know, from my perspective and things that I've witnessed. And I was like, yeah, I'm not going to be silenced, you know, because of fear. I'm going to confront it.
Right.
And that's where I'm at.
Yeah. And I mean, a lot of times, I mean, I think that's kind of where it is. I mean, as far as like challenging and arguing, if they don't like the arguments that you're making, then it could have an impact on a person's career when they're challenging the system and they're challenging judges and some certain decisions that are being made. Because basically the way that the system typically runs, regardless of what jurisdiction you're in, is that basically sometimes the logistics of the court oftentimes make it is more important than the individuals themselves. So in other words, if you're challenging things or you're taking matters to trial, kind of like everything goes from a system. You know, someone is charged with a crime. After they're charged with a crime, then basically they kind of like take a plea deal, and then basically, you know, you walk out of the situation. And basically the way that judges are very interested in settling cases, you know, and oftentimes the encouragement to settle cases is oftentimes not necessarily geared towards addressing the issue as to whether someone is guilty or innocent. It's about how can, you know, this is a good deal, without necessarily knowing what the the facts of the case are. So that prevents, in many ways, the attorneys, you know, or even their clients from really litigating the case. Because sometimes, you know, judges act more as a mediator prior to trial than they do someone who is basically taking a seat of basically someone who's not interested and just want to be see that justice is administered. And so for me, I think that I'm extremely disturbed by the fact that attorneys are very limited in their ability to challenge the judicial system. I think that basically whenever there's laws that are implemented, I mean, you have to look at the way that laws typically work. You know, whenever you look at a landmark Supreme Court case or any Supreme Court case, whether you're talking about state court or whether you're talking about federal court or even appellate court cases, there's usually not a unanimous decision. So let's just say, for example, you have 9 Supreme Court justices and you go in front of the Supreme Court and you get a decision that's typically 5-4 or 7-2, whatever the split is. So you got 9 individuals who are looking at the exact same case, the exact same facts, and the exact same law, and they're split in their decision. You see what I mean? So, you know, to me, that tells you that how an individual's biases and an individual judge's paradigm changes the way in which you look at everything. So let's just go back, I mean, to the Dred Scott case. And for people who don't know who Dred Scott was basically a runaway slave. Well, not runaway slave. He was a slave who technically bought his freedom, I believe, in one jurisdiction, and then he went to another jurisdiction, and they did not recognize the fact that he was a free man. Yeah. And then he appealed his case all the way to the Supreme Court, and the Supreme Court said that they found a procedural issue, saying that he could not adjudicate his case because he was a farm animal, that as a black man he was a farm animal, so he couldn't adjudicate the case. This is a Supreme Court decision, which technically someone may say that the 13th Amendment got rid of that, but it was never really an overturned case. But this is something that the courts had made a decision on. Now, just imagine if someone challenged that decision, that would have been considered a frivolous decision. If after Dred Scott decision, if you would have went to court and tried to represent an African American in federal court after the Dred Scott decision, but before the 13th Amendment, technically, it would have been a frivolous appeal or a frivolous case. And so, you know, that's the disturbing thing to me, is that we should be free to challenge cases when we see fit, because that's how laws are actually changed. And that is really the most significant aspect of it. That's why all of most of our freedoms come from that whole challenging the system, you know, situation.
One of the things that I'm reminded of when you were talking about that is there is some things that we can do as attorneys in order to challenge a judge. I remember early on in my career that I had challenged a judge, and I immediately seen the bias, and I papered her. And I was nervous. I was a rookie attorney coming in, and I'm about to challenge a judge. And when she got the paper, she threw it in the air. And she said, "Get out of my courtroom. I'm sending you to a different, court. I can't hear the case." But she was mad, and I knew that could never return to that courtroom again. But, it's something that we have to do as attorneys. But you're right. Like, if an attorney would have came back after that Dred Scott case, before the 13th Amendment, they probably would have been sanctioned. Yeah. Right? And there is complaints that are actually made, and there is some follow-ups, but it seems like they don't go anywhere. I mean, we have statistics in front of us, both for the California and for the federal system, and we could see, by the plain text, that these complaints go nowhere.
Yeah, I mean, it's very, generally when you're complaining against a judge, I mean, it's very difficult because usually, a judge's discretion is very seldom, overturned or messed with, I guess, for lack of a better term. And I think that basically when you're looking, and then also, you know, they have the powers to deal with sentencing. They have powers to deal with so many different things, and that's another thing, is that when we see judges who are involved in things, and we talked about this earlier, or in our past few shows when we talk about things about getting involved and knowing who these judges are and knowing what kind of decisions that are being made by some of these judges, we don't pay attention enough. And I think that there should be some sort of scorecard, you know, that we keep to see how these judges are ruling on some of these cases. You know, like, for example, you know, it's so important. For example, like, let's just say that you're going to trial. You know, we're going in front of a jury. And we talked about the importance of a jury, and a jury is extremely important. But oftentimes, some of the things that the jury can and cannot hear is oftentimes in pretrial litigation or pretrial motions, they're limited to hearing certain things, or there's things that they should not hear that's allowed to, or certain evidence that's excluded, you know, that makes a big difference. And I remember one time that there's a murder case with a guy who actually was accused of murdering someone. And prior to him going to trial, there had been 12 years earlier, he had been accused of attempted murder. And ultimately, that case was kind of overturned. And so when he was accused of the murder case, then the DEA was trying to introduce evidence of the prior case that had happened like 12 years earlier. And the argument was that the judge felt that it was probative and not prejudicial, because it was more probative than being prejudicial, because it showed a common plan or scheme. So they were going to allow the victim of the prior case 12 years ago to testify. Well, one judge, the first judge, said that ruled that it was admissible. Somehow something happened and it was a mistrial even before it got to the jury, or even before the jury was selected. It was continued. Then when it went back to another judge says, no way. That's nothing but, that's extremely prejudicial. There's no probative value as to what happened 12 years earlier. Now here you got a guy that's got his life on the line. You got this judge that's making this decision. And people don't understand when you go in front of a judge, it's like, you know, gang stuff, you know, these gang allegations. When they say, I'm going to, you know, say that I'm going to let this gang information in, that he was basically rolling with this set or rolling with that set, which may or may not be completely irrelevant to the case. And basically what happens when juries are allowed to hear prejudicial information, then jurors make decisions based solely on the prejudicial things that they hear, and the judge can kind of set the he don't make the decision. He does make the decision when it comes to sentencing, but he sets the whole landscape, the tone of the whole case.
Exactly.
I had judges that basically slept on the bench when I did my case in chief. They rolled their eyes. There's things that judges can do that basically, you know, the same way with jury selection. You know, for example, like when you say someone says, can you be fair and impartial? And a juror says, no, I can't be fair and impartial. Now, for me, if someone says that, they immediately should be kicked off the jury.
Exactly.
That's right.
But what do? They'll talk to them, and the judge can intimidate them to the extent that they'll change their mind.
Yep.
And it happens all the time.
Yeah.
Every day. I mean, I've witnessed that so many times where that person should be off, and now we're in a situation where we have to use one of our challenges to
Right.
get them off.
Right.
When we shouldn't have to.
Exactly.
Giving the prosecution an advantage.
Yeah. And that's what they do. They call it the judge rehabilitates them. You know what I mean? Just because he doesn't want this, and I appreciate judges. So I've had certain. There's a judge actually in Banning. His last name is Hernandez. Great judge. He does the voir dire. You know, he basically, if you have anything that would suggest that you're going to be, Jorge Hernandez is his name, I believe, Judge Jorge Hernandez. If you say anything that's going to show that you're going to be biased, you're out of there. That's the right way to do it. right?
That's right.
You know what I mean? I mean, if he has to call in an entire new panel because all of the jurors are gone, he's going to do that because that's justice.
And I think it's important to do that because, I mean, at the end of the day, we're dealing with somebody's freedom. We're dealing with somebody's life, a family. And, you know, we can't just assume that these people are guilty, but there needs to be these safeguards, and these judges need to step up and do the right thing instead of, you know, thinking about time. Because a lot of time they're guided by their calendar. And, you know, I don't got a lot of time. They just go ahead and push this thing forward. But I don't know if the solution is that we need more judges, but we definitely, there needs to be some reform.
Right.
You know, I was reading up on, you know, the statistics in regards to judicial misconduct with the CNN report, and it says that about 1,000 cases are reported on judicial misconduct annually, but very rare is they investigated, or if they are investigated, it's not investigated deeply. And then because it's not public information, then, you know, the judge's name, you know, the judge's names is not being put out there. But I'm wondering that if it was made public, will we have a different outcome to a lot of these cases? You know, whereas you can see, you know, maybe prosecutorial misconduct, it can be made public. And so, of course, it can be stopped. And, of course, we talked about the laws that was made against them, you know, I guess in the, you know, years ago. But now we look at judicial misconduct. I'm wondering if that same information was made public, will we have less cases like this?
I mean, I think so. I think that, you know, transparency is always good, and I think that if we're in a situation where the public is finding out, like, hey, there's these allegations just from misconduct, for at least for those judges that are elected, they probably wouldn't be reelected.
Right.
I mean, you know, think of it just like if it was a situation, if it was one of our local politicians and there was all these allegations against him and they come up for reelection, you know, they might not make it to another term.
Right. I see that. Yeah, I mean, I do. I think that if there is a report card on a judge, I mean, and some people, they do keep, you know, certain political organizations may keep certain statistics on judges, and we do know that judges, based upon their political leanings and who they're appointed by, sometimes, you know, their decisions and the way they conduct their courtroom is probably reflective of the way that, you know, they're and you also have to keep in mind that most, especially federal judges, they're appointed. The same way with the, you know, state judges. Oftentimes, although there are elections, how they initially get to the bench oftentimes is by, you know, some sort of appointment. So, you know, what are the qualifications to become a judge? Typically, you just have to be an attorney or licensed as an attorney for a certain period of time. And you don't necessarily even have to have courtroom experiences. You know, I don't know. I think there's a very few of all the Supreme Court justices that I think of. The only one that I know that argued a lot of cases in front of the Supreme Court was Thurgood Marshall, and many of the justices in the Supreme Court never even argued cases. That's not really what they did. Like, for example, some of them were, you know, heads of certain organizations. Some of them come out of academia, and they really aren't you know, litigators themselves. You know, they're more like scholars. And oftentimes when you talk about scholarship, you're not actually talking about real people. And oftentimes what you see with these decisions that you're getting and people that are needing immediate relief is that you have these judges who are making these decisions and they're not really thinking about the individual, they're just thinking about the political backlash. You know what I mean? And so that's, you know, troubling, because a lot of times, based upon who the litigant may be, it's just like some of the cases that go to even some of the most liberal of the circuits, or whether you're talking about conservative circuits, there's cases that end up in the Supreme Court just because, you know, it's a hot topic, and not because there's really a need for relief. Because the way the Supreme Court works is Supreme Court doesn't have to listen or don't have to hear every case. But there's some of these cases that they're hearing just simply because of the politics, you know, the same way that they deal with them. And they know that, you know, sometimes that's kind of the shine. I got this case, that this one case they're not hearing, but they're hearing these other cases, and there's people who need their cases heard. And that's kind of the selection. It's the politics that goes along with the judiciary. and people are suffering because of the politics of the judiciary, the politics of the cases that are important that they need to hear. They're not listening to them. Or you got people who are in prison who are actually trying to appeal their cases, and they're not getting any relief because the Supreme Court doesn't want to give them any love because there's no politics behind the love. You know, that's why would somebody have to appeal their case for 25 years to get out and find out that they're innocent? Why did Geronimo Pratt have to do what he had to do? Just simply because the courts are not responsive to people. They're responsive to politics. They're responsive to their own biases. They're responsive to things that aren't about, you know, the humanness aspect of it is completely taken out of it, you know, and you're shutting the courtroom doors to people because of some sort of procedural error, or you're talking about a situation where I'm going to cut the doors because, you know, the time is ran out. So you're going to have a guy like, you know, someone makes, for example, we have cases that we're going to talk about later where someone was accused of doing something 15, 20 years ago, and they're able to prosecute them, but then you get someone who's beat by the police, and then they're going to deny your right to go to court because you didn't make your you know, it didn't happen fast enough, or they do some sort of summary judgment motion, you know, and a summary judgment motion is that in the civil arena, if you don't have the resources and the money, the courtroom doors are shut on you because you're going against the city who has the top, you know, they have, you know, countless lawyers, and you go to a young maverick who's trying to fight for this guy, and he doesn't have the resources and the money to fight against the city. And now because you can't get your expert in time, or because, you know, you don't have the depositions done in time, or whatever, they're getting demurrers and summary judgment and completely closing the doors, and not once sitting there thinking, well, you know what, maybe I should give him a little bit more leeway because he don't have the same resources that somebody else has. And that's kind of how they look at it, these little technical things that they do, and it's more of not allowing you to use up the court's time than it is anything else.
So would you say that the pressure would be upon the defense attorney? Let's say hypothetically a prosecutor come with a deal, and you don't feel it's a good deal. Let's say the judge kind of insinuate that it is a good deal, but you go against those wishes. So do you think that now that you went against that judge, would you see that as judicial misconduct or bias because he's actually suggesting that it's a good deal? Or would that, you know, the pressure be upon the defense attorney to accept that deal?
Yeah, it is. I mean, one of the things that always crosses my mind in these cases is when you're convicted, right? You get a conviction, and just say, for example, you're adamant about the fact that you didn't do something, and you go to sentencing. And if you go to sentencing and you say, Your Honor, I really didn't do this crime, you're going to get more time, because they're going to say you didn't show any remorse. You see what I mean? And so you have to always, attorneys are stuck with trying to coach their client into admitting guilt when they might not really admit guilt, because that's one of the factors that they hold against you. And then the judge is going to give you more time. And he's the one that's going to give you the sentence. That's the one who gives you the time. And oftentimes, you know, I see that, or maybe you didn't take the deal. You know, maybe the judge sees it that sometimes in open court they put these offers on the table and they say them in open court sometimes before you go to trial. And then when you're found guilty, you know, is that in the back of the judge's head that you didn't take the deal? You know, you see what I mean?
Can I jump in there really quick?
Sure.
Because there was an example that I thought of when you were saying that. When I first started off, I started off as a law clerk working with the prosecution. And I remember a case that they gave me, some like low-level, like misdemeanor, and it was going to trial. So they're allowing me to try the case. So the PD was a guy that had a lot of experience. He was about to be promoted to the felony panel, and we're going to go against each other, right? And the judge tells him, you know what, if you lose, don't think your guy's not going to do jail time. Like, I'm gonna get him. And he should have normally, jail time shouldn't have been on the table for that kind of offense. But I think that the judge just didn't want to waste his time. And I believe that he did coerce him into taking the deal. And for me, I was ready to go at it no matter what. But that's a perfect example of what you're saying, because I believe that that person was coerced. All of a sudden, they were ready to go to trial, and now they're signing the deal.
Well, let's circle back to the attorney. So, and you know, I speak from the street. Now, look at this. You guys have made the case and made it extremely well that the resistance in the courtroom viva the attorneys towards the judge. Street people look at the attorneys as the defenders of faith. Okay, so if those attorneys are in reserve for saying and doing what's needed to be done in the courtroom, how do you think the average citizen feels going in there when they're dependent on that attorney to be the safeguard for their survival, for keeping them out of jail, etc.? So when you talk about possible solutions, you know, I truly think it's got to be a proactive series of watch groups. I love the concept of the scorecard, but unilaterally, it has to be numbers, because you're not going to get the average citizen by himself standing up in a courtroom knowing the dynamics of what's going to go on and what's going to happen to that individual. And then if the attorneys are not fighting for that individual too, that individual at the end of the day is going to be an albatross in that system. So if we're really going to attack, and going back to some of the previous shows, I think strategically planned work groups that have a defined mission, and I think a collaborative, of street invested individuals, people who have the right intention within the court system, who represent, as you do as attorneys, and that power base that will move that attorneys, move the judges, watch what they do, keep a scorecard, what they do, and most importantly, not be afraid to attack the system in terms of referencing that judge and bringing to the forefront what that judge's record looks like. Because if it's not a power base that's working in cohesive collaboration, you're not going to get people standing up against that system. And I think we see that for decades of what we've seen in this country, in this unfair judicial system, and how it operates and how it confines and tries people.
Yeah, I think that sometimes, I mean, the thing when you see very, very aggressive attorneys, and I consider myself to be an extremely aggressive attorney when it comes to the courtroom, and I know that Chris is too. Sometimes when you get on a roll, I mean, sometimes I feel like if you're on a roll, then they kind of slow you down. If you're really doing good and you're going at the witness and you're really fighting for your client, you know, I even had, you know, one time when a judge, you know, I mean, I was really at it. I was going at it. And he was like, told me that I was making facial expressions and not to make those facial expressions. I'm like, what facial expressions? And I tried to get him to explain to me what the facial expression was. What was I doing? You know what I mean? And then eventually he just finally, he says, well, rolling your eyes. I said, rolling my eyes. I said, I don't roll my eyes. But, you know, that was kind of his way of, I felt like that he was trying to put the handcuffs on me and, you know, make it a little bit, you know, softer for the other side, specifically the prosecution. You know, that's the way I felt. You know, I'm just saying that's just the way I feel. And oftentimes I feel like, you know, and oftentimes I'm sure I'm not the only defense attorney that feels like that, Chris. Right?
No, you're not.
You know.
Well, you know, you represented my daughter once, Brother Ali, and you did an outstanding job. And the tenacity and the power base that you brought into that room, I know if you didn't bring it that way, that my daughter would have been convicted of something that she did not do. And, you know, that being hampered in certain courtrooms, it does raise serious red flags, because you have to be able to come with that emotionalism and that fire, bringing points to validate. And if those are not pushed forward by attorneys, it really does the client a serious injustice in terms of speaking to the issue. A lot of judges based on the passion of what's being brought to the table. And if there's no passion in that, a lot of times they'll say, well, it must not be much of a belief in where he or she is going, because the passion seems to be missing from their voice. And to have that hampered is just not acceptable. We got to change that dynamic.
Right. Yeah, and it is. I mean, it's a frustrating situation. And I think you have a lot of great attorneys who really want, and they feel that way. I remember, once an attorney was telling me when I first started that basically when you go in the courtroom, you feel like everybody is against you as a defense attorney. You know, the prosecutor's against you, the bailiff's against you, the judges against you, and you feel that way because sometimes because it's kind of like these people do this thing together every day, and there's a system of the way things are really done, and every system kind of it's almost like a what do you call it? When you're in a factory and you kind of like go through this system and everything happens the same way every day. Assembly line. And that's kind of how it goes across. It goes across as an assembly line. And not once does anybody consider whether this individual may or may not be may be innocent. Yeah. It's just kind of like, okay, this is what deal are you asking? And it immediately becomes a deal assembly line for the most part.
One other possible solution is local bar associations. Like in Orange County, we have an Orange County Bar Association. I don't know, do they have that in Riverside?
Oh, you're talking about like the river? Yeah, they do have a local bar association.
Yeah, and I know that our bar association is pretty active in communicating with the judiciary and have been involved with certain judges, being moved to different departments if they're not working out there. And so I don't know if other counties have that kind of pull or they're organized in such a way, but I know in Orange County, that's what they're doing that's positive in regards to defense attorneys.
I wanted to say something real quick where, me and Akil, we basically on the streets, and I look at you and, who we encounter on the street is who you might end up representing one day. So you doing the footwork inside the courtroom. And so, just being a soldier or a warrior on both of those sides, and looking at, what you said earlier about you had second thoughts about, coming on here because the repercussions, because people think like that, but that just shows that you have that non-biased opinion. The thing about it is this: I salute both of you guys, and you for coming forward, because there are some people that say, nah, I'm not going on the radio station, I'm not making that sacrifice, but you guys are making that sacrifice by, confronting the issues that are in that courtroom, knowing that you can go in there next week and somebody can hear that and the judge be biased towards you just for this radio station, just for, putting it out there and making the public aware of things that they're not aware of, because that's what the radio station is, to make the public aware of things that they can't see behind the scenes. You see the things because you're in the courtroom every day, and so I salute you both, for being, battling that front.
I totally agree.
I appreciate it. Like I said, I mean, I'm always, the reason that I got into the legal field was because of the Mavericks, man. I mean, we don't see that anymore. I mean, like, for example, nowadays, you hear the lawyer jokes. You hear people saying they have negative opinions and attitudes about lawyers. But when I grew up, and I was born in the 60s, and
much more respect.
Yeah, I mean, it was a different. Your role was to make that difference, and you don't see, those type of attorneys anymore. You don't see those type of people fighting in light of what's going to happen to you. You're going to do that, and we're not talking about attorneys who put their careers on the line only. They were going to places that they were going to get killed. Just simply not just I'm fighting this fight and then putting my career on the line. The fight that I'm fighting may cost me and my family their lives. And these were the kind of attorneys that was there. And those are the type of people that we need to be in these positions that are willing to put it on the line like that. I don't think that there's, for me, I don't think there's really any other way. If I couldn't do that, there's no use in me doing this. That's the way I see it, or for anyone else. But
we used to have a saying back in the 60s, if you're not ready to die for your belief, you don't believe it. Yeah. And I'm not saying anybody go out and commit suicide or assassinate, no. Yeah. But what I'm saying, you've got to have the integrity for what you stand for and the tenacity to move forward with it, and worry about the consequences as they may come. In life, that personal sacrifice, it really defines character. And we have lost so much of that in terms of the cowdowing of how people affiliate. Well, I've got to keep the comfort zone. I can't make any waves. Revolution was built on waves, and when we look at who has constituted real change in this country, it's been those that have been willing to step out and sacrifice, not only for themselves, but sacrifice for any and all that they were standing for. Taking a stand is not taking a sit. Yeah.
Well, what's amazing to me, basically, is that, most of the communities that are the most affected tend to be the ones who suggest they have the most faith, whatever that faith may be. It could be in a deity, it could be in whatever. Well, if you got the faith, what are you scared of?
What are you afraid of?
What are you afraid of? Like, I'm not, you know what I mean? That's just the way I see it. Don't tell me you have this faith, but then you're scared of what's going to happen to you if you step out. That's the challenge. You're being challenged by not doing that. And that makes no sense to me.
And you know what? That's funny that you're saying that, because that's what got me here ultimately. Because at the end of the day, I kind of did an evaluation of myself, and I was like, you know what? I'm going to be a judge no matter what. And I was like, I'm called to speak. I'm not called to be silent. And I'm going to put myself out there. Let's just go for it. And I'm used to having my back against the wall. I walk into a courtroom, I have a tattoo on the back of my head. People that are hearing us can't see the tattoo, but if you see me in court, everyone knows me. When I walk in, they think that the bailiff's going to shoot me or something. And I start walking past everybody.
That's the right guy.
And I'm a very reasonable person, but I'm also very outspoken, and I will fight you. And that's just my character. So when this opportunity, was brought to me, I did think about it, but ultimately I chose to be here because I know it's the right thing to do.
Exactly.
Absolutely.
Excellent.
All right. What do we got?
Well,
in the
as the only female in the panel, I would say that, as females, I feel like sometimes we're kind of scared to step up to the plate because we have cases like the Bill Cosby case, where women are kind of talking about the issues that they're undergoing and that they're being sexually assaulted, but nobody is really listening to them. And it takes a movement like the Me Too movement that was created to kind of enhance this strong sense of community among people that have been sexually assaulted for women to kind of be out there and be heard. So, yeah.
Yeah, Bill Cosby. We know that. I think it was yesterday or the day before when obviously he ended up being found guilty. I think there was all 3 counts of assault and sexual assault counts against him, where he was ultimately accused of drugging and sexual assaulting. At least in this case, I don't know how many victims. I think in the case there was actually 1, but I think there was actually
they said like 60 or something.
60 other people, yeah. So, and now of course California basically changed the law based upon this. California is notorious for changing laws as a result of high-profile cases.
Exactly.
And obviously, They make the laws, but then there's an administration. Again, they're not. The legislatures aren't involved in the administration of justice. But at any rate, I've heard a lot of different opinions about Bill Cosby and the verdict and whether he should have been found guilty or innocent. I don't know because I wasn't in the courtroom. I didn't even see the court case, so I'm not going to speak on whether he should necessarily have been found guilty or innocent. But what I will speak on is that I do know we talked about the jury. I believe it was a 10-2 was the split. I think there was 10 Caucasian and 2 African Americans that were actually on the jury, and it was a unanimous decision. He was found guilty. I mean, that's, that is what it is. I mean, we have a lot of individuals that, feel like that he was targeted for whatever reason, but yet and still at the end of the day, he was found guilty. So that's,
yeah, like you say, there's a lot of different opinions about the case, and there's certain people that sway one way and certain people sway the other way, and of course you're gonna have that in any case. I've always been the person that kind of questioned why so long. I understand the statute of limitation had ran out on certain, but I think once you become of age, I don't think that out of 60 people, everybody was scared in some sort of way. And I just believe that, at some point, out of 60, even if 2 came forward, it would have said something before the statute of limitation ran out. And I think that when you become of age and intelligence, you know right from wrong, and you know what needs to be said. And that's not saying that people, wasn't, scared, because I believe that, people do generally get scared of power, when a person does have power. But, I just look at the, the numbers, 60 people. I just don't believe 60 people could have been intimidated or 60 people could have been scared. It takes one person, and then,
Well, to
people come in.
piggyback on what you said, Mike, look, I'm a staunch defender of women and children, and if he actually did what he did, he needs to be put where he needs to be put. But it goes back to everything we've been talking about all day. You cannot trust the judicial system, and so we're going to have the reserves because you put him in this system, a system that we don't trust, a system that has historically been against people of color. You try him with people that have a perception created about him, and so at the end of the day, because of that lack of trust and the lack to believe in the system, there is going to be doubt that this man was tried fairly and given an equitable capability to defend himself, to information to be brought to the table, et cetera. You're going to have people that will never believe, based on the judicial system and how it has treated people, that this man was guilty. It doesn't have anything to do with him. It has something to do with that system.
Exactly. And I'm a big defender as well. Women and children, I'm a big defender. But sometimes you only get what you can get. The public the public, like we were just talking about the judicial misconduct. We don't know who the judges are. That actually do this. So there's only a bit of information that is actually given out to the public. So we're just there to get what we're given through the media, and because for so long they neglected our needs and stuff, we failed to believe in them for so long. So.
Well, let's just think about Emmett Till. Let's think about, people of color who have been held by that system because certain people of other persuasions said they did A, B, and C, and people were assassinated, lynched, etc., based on what people have said. That also comes into
exactly.
So,
exactly.
I mean, I'm not real quick. I'm not really moved by numbers. I mean, the thing that I've always noticed is that we, kind of think that we know some things, just the things that we presume. In other words, just the allegation. If you say, well, if it was only one person, yeah, but if 50 people said it, it's got to be true.
No.
If 60 people said it, it's got to be true. I mean, and that's kind of the way that people kind of see things,
Exactly.
But the reality of it is that that's not, that's it's about the evidence. I think that just purely an allegation is not enough,
And look at the opportunity of those 60 people.
Yeah.
Could some of them have benefited greatly?
Yeah.
Yes.
Yeah.
So there's a lot to be discussed.
Yeah, a lot.
Yeah. So
one thing that stood out to me though, in regards to the defense of Mr. Cosby, was a quote that I had read from his defense attorney when he was addressing the jury, that mob rule is not due process, and basically was addressing the Me Too era. And if you consider that from the first trial to the second trial and seeing how things had just kind of like really amped up, it's like Bill Cosby's back was against the wall. I'm not trying to say he's innocent or guilty. I wasn't there, just like you had said that. But with the Me Too era, I think that somebody that's high profile and has a high profile case, like they're in trouble.
Yeah, most definitely, most definitely. So yeah, I know that we'll see. I know that he actually is in a situation where he's going to be sentenced. I know he's looking at 30 years, I believe, because I think unless they run them concurrently. Mm-hmm. But at any rate, again, I'd like to appreciate Mr. Attorney Hernandez for showing up today. It was really insightful in your input, and I appreciate you coming in and being one of those people on the front lines that's willing to put it out there like that. So, that's what we need.
Thank you.
And that's kind of, again, what we need, and that's what makes a difference. Mm-hmm. And also, again, from the Justice Watch crew, Rosa Nunez, Michael Bilal Clark, and Dr. Akil Bashir. Like always, we appreciate you guys for tuning in, and we invite you back next week, same time, same channel, when we'll talk about some more critical issues in the criminal justice system. Until next week, see you later.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
Your NBC Sports Radio update starts now.